The January 2026 Visa Bulletin has just been released, and if you're waiting for a green card through family sponsorship or employment, this update contains critical information that could directly impact your timeline. Some categories have seen forward movement, others have retrogressed, and for certain countries, the wait just got longer. I'm going to break down every major change in this bulletin, explain the policy mechanics driving these movements, and help you understand what this means for your case. Whether you're in EB2 India facing years of backlog, F2A trying to reunite with family, or EB3 worldwide watching dates inch forward. This is not speculation. This is analysis based on current USCIS operational patterns, visa demand data, and how the annual quota system is being managed as we move deeper into fiscal year 2026. Let's get into it. Before we analyze the January numbers, let's establish what the Visa Bulletin actually represents and why it matters. The Visa Bulletin is published monthly by the U.S. Department of State. It tells you whether your priority date, the date your petition was filed, is current enough for you to move forward with adjustment of status or consular processing. Think of it as a queue management system for a limited resource. Every fiscal year, which runs from October 1st through September 30th, Congress allocates a fixed number of immigrant visas. For family-based immigration, that's approximately 226,000 visas. For employment-based immigration, it's around 140,000. These numbers can fluctuate slightly due to unused visas from previous years, but the baseline is statutory. The bulletin has two charts. The final action date chart, which determines when you can actually get your green card, and the dates for filing chart, which sometimes allows you to submit your adjustment application early if USCIS announces they're accepting those filings. Not all months allow dates for filing usage, and USCIS controls that decision independently. When demand exceeds supply, which happens consistently for countries like India, China, Mexico, and the Philippines in certain categories, the dates for filing chart becomes retrogressed. That means your priority date must be earlier than the listed cutoff to proceed. If it's later, you wait. According to current bulletin trends, we're seeing continued strain in several high-demand categories, and that's shaping the January numbers. We are now 4 months into fiscal year 2026, which began on October 1st, 2025. This is a critical detail because visa issuance patterns follow predictable rhythms within each fiscal year. Historically, the first quarter, October through December, tends to be conservative. USCIS and the State Department are cautious about advancing dates too aggressively because they need to gauge demand, assess carryover visa availability from the previous year, and monitor how many applicants are documentarily qualified and ready to receive visas. By January, we typically start seeing clearer signals about how the rest of the fiscal year will unfold. If demand is lower than anticipated in certain categories, dates may advance. If demand surges, or if spillover from unused family-based visas into employment categories hasn't materialized yet, movement slows or stops. Based on how USCIS has been operating recently, we're seeing a mixed picture. Some categories are benefiting from spillover dynamics and relatively lighter demand. Others, particularly EB2 and EB3 India, are facing the compounding effects of decades-long backlogs and per-country limits. One major policy factor to watch: the 7% per-country cap. No single country can receive more than 7% of the total employment-based or family-based visas in a given year. For countries with massive populations like India and China, this creates severe bottlenecks. Even if you're highly skilled and your petition was approved years ago, you're competing within your own country's queue. Analysts believe that unless Congress passes legislation to reform the per-country cap system, these bottlenecks will persist throughout fiscal year 2026 and beyond. Let's shift to employment-based green cards, which are divided into 5 preference categories: EB1, EB2, EB3, EB4, and EB5. Each has different eligibility criteria and different levels of demand. EB1 is for individuals with extraordinary ability, outstanding professors and researchers, and multinational executives. EB2 requires an advanced degree or exceptional ability and includes the EB2 National Interest Waiver subcategory. EB3 covers skilled workers, professionals, and other workers. EB4 is for special immigrants, including religious workers. EB5 is the investor category. The majority of demand, and therefore the longest waits, are concentrated in EB2 and EB3, especially for India and China. EB1 has historically been current or near current, but we've seen retrogression in recent years due to increased usage, particularly from India. In the January 2026 Bulletin, the patterns we're observing reflect both demand dynamics and USCIS's management of the annual quota. Let's go category by category. EB1 worldwide remains current in the January Bulletin. That means if you have an approved EB1 petition and you're from a country other than India or China, you can file for adjustment of status or proceed with consular processing immediately, regardless of your priority date. This is significant. EB1 used to be a guaranteed fast track, but between 2018 and 2023, we saw periodic retrogression, especially for India and China, due to increased demand. Many EB2 and EB3 filers, frustrated by long waits, shifted to EB1 by filing extraordinary ability petitions, which drove up demand. However, according to current bulletin trends, EB1 worldwide has stabilized. This suggests that demand has either plateaued or that USCIS has allocated sufficient visas to keep the category current. For India, EB1 shows a priority date of March 1, 2023. That's a modest forward movement of about 2 months compared to the previous bulletin. For China, the date is October 1, 2022. This is not dramatic progress, but it's movement nonetheless. If you're in EB1 India, this 2-month shift might not feel like much when you're waiting years, but it does indicate that visas are being issued. The pace is constrained by the per-country cap, not by lack of available visas in the EB1 pool overall. If current policy direction continues, we can expect EB1 worldwide to remain current through the rest of the fiscal year, with gradual forward movement for India and China as demand allows. EB2 worldwide, meaning applicants from countries not subject to per-country backlogs, also remains current in January 2026. If you're from a country other than India or China, your EB2 green card process can proceed without waiting for a priority date to become current. This is consistent with historical patterns. EB2 demand from rest of world countries is generally manageable within the annual quota. The real challenge is in India and China, where decades of high-skilled immigration have created multi-year, sometimes multi-decade backlogs. The fact that EB2 worldwide is current suggests that spillover visas, unused visas from family-based categories that roll over into employment categories, are being distributed effectively, at least for countries without retrogression. However, this does not mean the situation is static. If demand increases, or if spillover patterns shift, we could see retrogression even in worldwide categories later in the fiscal year. USCIS retains discretion over how aggressively to advance dates, and they tend to be conservative to avoid running out of visas prematurely. EB2 India is where the employment-based system shows its most severe strain. The January 2026 Bulletin lists the final action date for EB2 India as April 1, 2012. Let me repeat that. April 2012. If your EB2 India priority date is April 2, 2012, you are still waiting. You have been waiting for nearly 14 years. Even though your employer sponsored you, USCIS approved your I-140 petition and you've likely been working in the US on temporary visas this entire time. Compared to the December 2025 Bulletin, this represents a forward movement of approximately 1 month. That might sound like progress, but at this pace, someone with a 2015 priority date is looking at another decade or more before their date becomes current. Why is EB2 India moving so slowly? The answer lies in the intersection of 3 factors: the per-country cap, high demand, and limited spillover. First, the 7% per-country cap means that no matter how many Indian nationals are in the EB2 queue, they can only receive about 7% of the total EB2 visas each year. Given that India represents a disproportionately large share of U.S. high-skilled immigration, this creates an artificial bottleneck. Second, demand from India in EB2 has been extraordinarily high for over 2 decades. Tens of thousands of petitions were filed in the 2000s and 2010s, and those applicants are still in line. Third, spillover, the mechanism by which unused visas from oversubscribed categories flow to undersubscribed ones, has not been sufficient to meaningfully accelerate EB2 India. Spillover typically happens late in the fiscal year, and even when it does, the volume is not enough to make a dent in a backlog of this scale. Analysts believe that without legislative reform, EB2 India will continue this glacial pace. Some advocacy groups are pushing for elimination or modification of the per-country cap, but as of now, no such legislation has passed. If you're in EB2 India with a priority date in 2013 or later, the hard reality is that you may be waiting another decade or more under current policy. This is not to discourage you, but to set realistic expectations based on how the system is operating. EB2 China shows a priority date of May 1, 2020 in the January 2026 Bulletin. This represents forward movement of approximately 3 months compared to recent bulletins. China's EB2 backlog is significant, but not as extreme as India's. The reason is partially due to lower overall demand and partially due to how visa allocation has been managed over the past several years. That said, EB2 China is still retrogressed, meaning applicants with priority dates after May 2020 are waiting. For someone who filed in 2021 or 2022, that's a multi-year wait, which can be frustrating given that EB2 worldwide is current. According to current bulletin trends, EB2 China is likely to see continued modest forward movement as long as demand remains stable and spillover visas are available. However, any surge in filings, particularly from individuals switching from EB3 to EB2 via interfiling, could slow or reverse this progress. If current policy direction continues, EB2 China applicants with 2020 priority dates may see their cases become current within the next 12 to 18 months, but this is an estimate, not a guarantee. Retrogression can happen at any time based on USCIS's assessment of demand. EB3 worldwide is current in the January 2026 Bulletin. This is excellent news for applicants from countries not subject to per-country backlogs. If your employer sponsored you under EB3 and you're not from India, China, Mexico, or the Philippines, you can proceed with adjustment of status or consular processing immediately. This reflects the fact that EB3 demand from rest-of-world countries is manageable within the annual quota. It also suggests that USCIS is distributing visas efficiently and that spillover is being utilized effectively. However, EB3 worldwide being current does not mean it will remain that way indefinitely. Historically, we've seen EB3 retrogress later in the fiscal year if demand increases or if USCIS becomes more conservative in managing the quota. Applicants should file as soon as they're eligible rather than waiting, because the current status can change in any subsequent bulletin. If you're in EB3 worldwide, this is your opportunity to move forward. Take advantage of it while the category remains current. EB3 India shows a final action date of February 1, 2013, in the January 2026 Bulletin. This is forward movement of about 2 months compared to the previous bulletin. Like EB2 India, EB3 India faces a severe backlog due to the per-country cap and high demand. However, EB3 India has historically moved slightly faster than EB2 India in certain years due to spillover dynamics and cross-chargeability strategies that some applicants use. Here's an important nuance. If you're in EB2 India and your priority date is earlier than the EB3 India cutoff, you might consider downgrading to EB3 to become current sooner. This is called downgrading or inner filing, and it's a strategy that many applicants use when EB3 dates are ahead of EB2 dates. However, based on how USCIS has been operating recently, the EB2 India date is currently behind EB3 India by about 9 months. That gap has narrowed over the past year, which means the downgrade strategy is less advantageous than it was in previous years. For applicants with priority dates in 2013 or early 2014, the January movement is a positive signal. It indicates that visas are being issued and the queue is moving, albeit slowly. That said, if your priority date is in 2015 or later, you're looking at many more years of waiting under current policy. Analysts believe that without legislative reform, the EB3 India backlog will persist well into the 2030s for recent filers. EB3 China shows a priority date of March 1, 2021, in the January 2026 Bulletin, representing forward movement of approximately 2 months. This is notably faster movement than we've seen in EB2 China, which suggests that demand in EB3 China is lower, or that spillover is being allocated more favorably to this category. For applicants with 2021 priority dates, this is encouraging. If current policy direction continues, you may see your case become current within the next 12 to 24 months. However, as always, this depends on demand patterns and USCIS's management of the quota. Mexico and the Philippines both show retrogression in EB3 as well, with dates in the 2021 to 2022 range. These countries also face per-country cap constraints, though not to the same degree as India. For rest-of-world EB3 applicants, the category remains current, meaning no waiting period beyond standard USCIS processing times. EB4, the special immigrant category, remains current worldwide in the January 2026 Bulletin. This category includes religious workers, certain international organization employees, and other special groups. Demand in EB4 is generally low, so retrogression is rare. EB5, the investor category, has been restructured in recent years following the passage of the EB5 Reform and Integrity Act. The January Bulletin shows that EB5 unreserved categories for China and India remain retrogressed, with dates in the 2015 to 2016 range. However, the new EB5 reserved categories, rural, high unemployment, and infrastructure projects, remain current or near current. If you're considering EB5, the reserved categories offer a faster path than the unreserved category, particularly for Indian and Chinese nationals. According to current bulletin trends, this structure is likely to persist as the reserved categories continue to see lower demand. Family-based immigration is divided into 4 preference categories. F1 for unmarried adult children of U.S. citizens, F2A for spouses and minor children of green card holders, F2B for unmarried adult children of green card holders, and F3 for married children of U.S. citizens, and F4 for siblings of U.S. citizens. Immediate relatives, spouses, minor children, and parents of U.S. citizens are not subject to numerical limits and do not appear on the visa bulletin. They can immigrate as soon as their petitions are approved. The preference categories, however, are subject to annual quotas and per-country caps. Mexico, India, China, and the Philippines face the longest waits due to high demand relative to the per-country allocation. The January 2026 Bulletin shows mixed movement across family categories. Some have advanced, others have retrogressed, and some remain unchanged. Let's go through each. F1 Worldwide shows a priority date of March 1, 2018, in the January 2026 Bulletin. This represents forward movement of about 1 month. For Mexico, F1 shows a date of July 1, 2000. That's a 26-year wait. For the Philippines, the date is May 1, 2013. For India and China, F1 is slightly ahead of the worldwide date, indicating lower demand from those countries in this category. The reason Mexico and the Philippines face such severe backlogs in F1 is due to high demand for family reunification combined with the per-country cap. These countries have large diaspora populations in the U.S., and many citizens petition for their adult, unmarried children. According to current Bulletin trends, F1 Mexico and F1 Philippines are unlikely to see dramatic forward movement in the near term. If you're waiting in one of these categories, patience is essential. Retrogression is always possible if demand surges or if USCIS adjusts its allocation strategy. F2A, which covers spouses and minor children of green card holders, is one of the most volatile categories in the Visa Bulletin. In some years, it's current. In others, it retrogresses by years. The January 2026 Bulletin shows F2A worldwide at September 1, 2024. This is forward movement of approximately 2 months. For Mexico, F2A shows a date of May 1, 2023. For India, China, and the Philippines, dates vary slightly, but generally align with the worldwide progression. F2A movement is heavily influenced by demand and by how many F2A beneficiaries adjust their status after the primary petitioner becomes a U.S. citizen. When the petitioner naturalizes, the beneficiary often shifts from F2A to the immediate relative category, which frees up F2A visa numbers. Based on how USCIS has been operating recently, F2A is likely to continue seeing modest forward movement throughout fiscal year 2026, barring any unexpected surge in demand. F2B, for unmarried adult children of green card holders, shows much longer waits. Worldwide, F2B is at October 1, 2017. Mexico F2B is at August 1, 2001. The Philippines is at October 1, 2013. These backlogs are the result of sustained demand over decades and the statutory limits on family-based visas. Analysts believe that without congressional action to increase family-based visa allocations, these wait times will persist. F3, for married children of U.S. citizens, and F4, for siblings of U.S. citizens, face some of the longest waits in the entire immigration system. F3 worldwide shows a priority date of December 1, 2010, in the January 2026 Bulletin. Mexico F3 is at October 1, 1999. The Philippines F3 is at August 1, 2004. F4 worldwide is at April 1, 2008. Mexico F4 is at April 1, 1999. The Philippines F4 is at October 1, 2003. These are not typos. People who filed petitions in the late 1990s and early 2000s are only now becoming current. That's a wait of over 2 decades. The reason for these extreme backlogs is straightforward. Congress allocated relatively few visa numbers to F3 and F4, and demand from countries like Mexico and the Philippines has been consistently high for decades. According to current Bulletin trends, forward movement in F3 and F4 will remain slow, often just a few months per year, unless Congress increases the annual allocation for these categories. If current policy direction continues, someone filing an F4 petition today could be waiting 30 years or more before their priority date becomes current. This is the reality of the U.S. family-based immigration system under current law. It's not designed to reunite families quickly in these categories. It's designed to manage a limited resource over a very long timeline. The January 2026 Visa Bulletin reflects the ongoing tension between demand and supply in the U.S. immigration system. Some categories are moving forward, others are stagnant or retrogressing. And for certain countries, the waits remain measured in decades. If you're in EB1 worldwide, EB2 worldwide, or EB3 worldwide, the system is working relatively well for you. Your path to a green card is clear, and as long as you maintain status and your petition remains valid, you can proceed without major delays. If you're in EB2 India or EB3 India, the situation is far more challenging. You're caught in a structural bottleneck created by the per-country cap and decades of accumulated demand. The forward movement we're seeing is real, but it's incremental. You need to plan for a long-term wait and consider all available strategies, including potential downgrading between categories, using dependent cross-chargeability if applicable, or exploring legislative advocacy efforts. If you're in family-based categories, especially F3 and F4 from Mexico or the Philippines, you're facing some of the longest waits in the system. The only realistic options are patience, staying informed about any legislative changes, and ensuring your petition remains active and valid. One critical point: the Visa Bulletin is not static. Dates can move forward, but they can also retrogress. USCIS and the State Department retain discretion over how to manage visa allocation, and they adjust based on demand, fiscal year timing, and policy priorities. That means if you're close to your priority date becoming current, you should be prepared to act quickly. Have your documents ready. Monitor the bulletin each month, and work with your attorney or petitioner to ensure there are no delays on your end. Finally, remember that immigration policy can change. New administrations bring new priorities. Congress can pass reforms. Court decisions can alter enforcement practices. What's true in January 2026 may not be true in January 2027. The best approach is to stay informed, remain patient, and be ready to adapt. This system is complex, often frustrating, and sometimes unfair. But it's the system we have, and understanding how it works is the first step toward navigating it successfully. If this breakdown helped you understand the January 2026 Visa Bulletin, please share it with others who might benefit. And as always, stay tuned for next month's update, where we'll analyze any new changes and what they mean for your case.